Okay, so we are going to get started with our presentation in just a minute. I'm going to pull up the PowerPoint and then I will introduce our training today. Okay. Philip, I'm going to ask you, since I know I can hear the other panelists. Can you see the PowerPoint right now?
Yes, I can see the PowerPoint.
Okay, great. All right, well, welcome to everyone who's with us today. We are going to be discussing tools and strategies to navigate challenges with client relationships. And I know that this is something that volunteers frequently reach out to us when they are having any kind of challenge with an individual client that they're working with. And so we really wanted to put together a training today to talk about some of those issues that may come up in your representation, and both kind of how you can get out in front of that from the beginning, so that you can make your relationships as smooth as possible, but also troubleshooting and what to do if you do get into a situation where an issue has arisen, what you might be able to do to address that. So my name is Margaret Henn. I am the Director of Program Management at MVLS, and I have with me Philip Westry, and he is our Baltimore Core Program Attorney at MVLS. And we might be joined by Sarah Witry, who's our Pro Bono Program Manager. She's currently having some technical difficulties. So the plan as of now is for us to just move forward with the training, but it's possible that she might join us later. And so I just want to thank you, everyone who's tuning in, volunteers. Thank you again for volunteering your time with MVLS and for joining this training. So I will talk a little bit more at the end of the training about MVLS and how to volunteer if you might be someone new who's joining us. But for now, we will go ahead and dive into the training itself. So some of the kind of common concerns that we hear from volunteers that we're going to be addressing during this training are a situation where the client is unhappy with the outcome of the representation, which is obviously something that happens. We are representing clients in cases that are can be very emotional, can involve the custody of their children or their housing, just things that are very extremely important in their lives. And so sometimes the outcome that client might want is full custody with no visitation from the other parent, and sometimes that might not be a realistic outcome. So that's something that we're going to talk a bit about in this training. One of the other concerns is clients becoming frustrated, or the attorney becoming frustrated because of communication issues. So the attorney might be trying to reach out to your client repeatedly, and they're just not calling you back, or they're not emailing you back. Or on the flip side of that, we have some clients who might be contacting you a bit too frequently, and you're looking to figure out how to kind of manage that relationship. So we're going to talk a bit about that as well. Dishonesty or not sharing the full truth. Obviously, that is a concern to attorneys. It is harder to represent your client if you have not gotten all the details and the full picture of what is going on in the case. So we are going to talk a bit about why clients might not have shared all the details right from the get-go, and also how you can develop trust and develop that relationship so you can have the most successful representation and get all the information you need to adequately represent a client on their case. Situations where the client is angry or frustrated to deal with those, how to kind of de-escalate, also when to reach out to MVLS if you're really having challenges. One of the things that sometimes comes up is third parties wanting to be involved in the case. So I've certainly had situations where volunteers have reached out where the client is a custody client and their mother wants to be very involved and is always calling the attorney. How is that something that you navigate as the attorney in the case? Obviously, a client can sign a third party waiver, but sometimes there's situations where it is or is not helpful to have a third party involved or advisable. So we'll talk a little bit about that. And then a lot of our clients, in addition to the matter that you're representing on, they have a lot of different matters going on in their lives, both legal and non-legal, in addition to the case that you've agreed to take on. So how do you set boundaries and also to effectively represent your client when they have so many different things going on in their lives? So these are some of the kind of common things that we hear from volunteers, and that was really the impetus behind this training, was to try to give some troubleshooting tips and talk through some of these issues. So one of the things that I really want to highlight at the beginning of this training, because I think it's really important to be at the forefront of your mind when you're representing a client, is when we're talking about all these challenges that I went through and just kind of challenges our clients face, why might a pro bono client be facing some of these challenges? Why might someone be, distrustful or have communication, differences from you? And so to kind of just think about that as part of the framing of how we're having this discussion. So I think one of the things that's important to keep at the forefront of your mind is the ingrained systemic racism in the institutions and systems in which all of us interact, but in which your clients interact. Many of our clients are Black, many from different communities that have been underserved by the legal system and also by basically every other system that we have in society. And so, clients are used to being told no by the legal system, not always being treated fairly, just having experiences with the legal system that are negative, whether that be the civil legal system or the criminal legal system. And so when you're thinking about your client's relationship with you as a lawyer, that may be where they're coming from in their memories of how they've encountered the legal system in the past. And so it is hard to put their trust in you as an attorney, because you are, as a lawyer, in their mind sometimes associated with that legal system. And so I think it's important to think about that when we talk about issues like a client not telling us the whole truth, for instance. Why might that distrust be there, and what kind of encounters have our clients had with the legal system in the past? Another thing, that can sometimes be impacting client relationships is, for instance, you have a client who's frequently late to appointments or something of that nature. So I think it's also important to remember the other barriers our clients might be facing that could be impacting their ability to make appointments. So it could be, think about transportation options, particularly in the city of Baltimore. The bus pretty much never comes when it says it's going to come. So it's very hard for a client to predict, when the bus is going to come and when they're going to get to their appointment with you. In terms of housing, whether it be a housing case or just the situation a client's in, there are a number of factors, present and historical, such as access to lending in the communities our clients live in, redlining, limited options due to not having established credit or having bad credit, that are often putting clients in housing with very bad conditions that could be impacting their health, impacting their family, and certainly impacting their ability to focus on whatever might be going on in the case. So I think it's kind of important to think about the clients, although you can't, we're going to talk about this a bit later, but although you can't resolve all of the non-legal issues your clients are facing, and that's not your role, it is important to think about the client in the larger structure of their life when you're thinking about some of these challenges that are coming up with your representation. And some of the things we're going to get a little bit more into as we go into the training are trauma and how that the client has experienced and how that might be impacting the case, as well as implicit bias on the part of various court officers, potentially on your part, that might be impacting how you're seeing that relationship. And so that's something we're going to talk about a bit more too. But with that introduction of, what this training is about, I am going to turn it over to Philip, who is going to talk about our first topic, which is defining the representation of your client.
Thank you, Margaret. And thank you to everybody who's here and who is going to ultimately listen to this as a recording. I wanted to comment on the previous slide and let you know that some of the mistrust or distrust that's sitting out there from folks, they don't always tell you about it, it's not always completely obvious to us, being people who are very comfortable going into the courtroom, talking to a judge. I had one client come in for assistance, and they described an interaction that they saw between opposing counsel and a judge in the courtroom that made them feel like they were already on the losing side of the case, just from the sort of casual greeting that the attorney had with the judge. So it's these little things that we don't always recognize that can create these situations where people feel like they're at a disadvantage because they're not sort of in the system and they don't understand the system as well as we may. So my slide is about sort of setting boundaries, specifically about the representation agreement. This is so important whether you're working with a MDLS client or if you're in private practice, to set up the scope of representation. And that representation agreement is helpful in defining what you will be able to do for the client. And then also the thing that I've noticed is missing from a lot of representation agreements are specifically the things you will not do. I'll give you an example. Before I started here at MDLS, I worked at a place called St. Ambrose Housing. During the foreclosure crisis, we expanded our legal services, but we had a very specific scope in mind about representing people at their foreclosure mediation, and that being the end of our legal services. So we would help folks negotiate with their servicer or their bank. And then we would go all the way through to the foreclosure mediation, but that was where representation stopped. And we made that very clear in our representation agreement. So we didn't have the person thinking that after the mediation, there was going to be a continued representation. And it was really helpful in the foreclosure example because people had other things that they wanted to do. Some folks wanted to sue their mortgage lender because they thought there was fraud and other things. And so it was really helpful to say, well, this was the scope, and we represented you and we completed what we could do. So that's really important. The other thing that's also good to put in those representation agreements are the sort of likely outcomes of what could happen in this case. And we all know, based on our expertise, that there really is only a range of outcomes, from a possible settlement to a a judgment being entered against your client, the range is there. And so it's really important to not overpromise when you're talking to a client, and set some realistic expectations about what can happen. Because sometimes people, they meet and interact with an attorney and they believe that we're going to be able to perform some sort of miracle when there isn't a miracle available in our system. And so keeping that expectation is really, really important. The next bullet is about the length of time. Again, using what we know. If we know that for example, right now we're recording this during sort of the middle of the COVID crisis. If we know that the courts are slower right now, it's something that's important to tell our clients from the beginning that yes, under normal circumstances, this case may only take 4 months. Now it's going to take 6, 8, or 10 months based on what the knowledge that we have. Really helps to let the client get an understanding that your relationship might go on pretty long in one type of case. And then there are times where your relationship is just for this one event where you have a limited scope case where you're going in to represent someone just for this very narrow hearing and that's all, or you're providing them brief advice. So it's really important to like set those expectations up at the beginning. And we have more information on our website about how you can, set up the, we have examples of representation agreements, and then we also are here to give you advice on how to set those expectations. I can do the next slide. So a lot of what I mentioned in the previous slide is about communication, right? For example, the project that I'm working on is sort of a special thing that we're doing, and it's in response to the pandemic. And I've helped a little bit over 100 people over the last 11 months or so, but all of that has been through email, phone call, and video conference, which is of course different than the work that I was doing pre-pandemic. So it was important for me when I first started interacting with my current clients to let them know we're likely never going to meet in person unless we go to court. And it was also helpful to explain to them, to get an understanding of what type of technological limitations they have, if they have access to a scanner or a fax machine, if they feel comfortable sending attachments via email. All of those things made the relationship easier as it went on. And I also recognize that it varied dramatically from one client to the next, as far as the level of coaching that I would have to give on how to, just give me information and how I would communicate with them. The other thing that I made that was important is that I have a couple of cases that are going to take 4, 5, 6 months. So I would tell someone, hey, we're starting this now. I'm entering my appearance in your case now, but there may not be an outcome for another 5 or 6 months. I'm going to set times for us to check in with each other. I have homework for you. I have documents that I'd like for you to try to obtain. And I would make it very clear, I'm going to give you a call in 2 weeks. I'll send you an email before that call. By the time we end up meeting, I need you to have obtained this document. And if you're having a hard time, let me know. Again, it's just helpful for the client because it makes them, one, feel like they're supported. And two, it goes back to the expectation. It's like, what do you need from them? What can they expect from you? Now, sorry, I'm just calling you Susan Margaret. Margaret mentioned sort of third parties being included in cases. I have a sort of personal opinion about how that should go. I do my best to encourage my client to avoid having a third party deeply involved in their case. I mean, we can get into conversations about attorney-client privilege or whether we want to do a third-party waiver, but at the end of the day, there's a limitation to what that third party can do for your client. they won't be able to testify in court on behalf of your client. Sometimes the third party simply they won't be testifying in court at all. They don't. They're more in a supportive role, and you really want to make sure that you're empowering your client to make their own decisions. And so, if for some reason there's a third party that's constantly sort of getting involved, there might be a problem with your communication with your client, and again, the expectations and the goals being set. If a third party is so easily able to sort of chime in, especially if they're not an attorney and they're not an expert. So there is the ability to do a third party waiver. I would recommend that you really talk to your client about the reasons why you wouldn't want that third party waiver, and empower them to sort of take control of their case in lieu of having, a parent or a friend kind of controlling the direction of the case. The documenting context is so important. It's an area that I had to improve on from when I started 8 years ago, to now, because it helps you to remember how many clients you're working with. I know a lot of us are very busy. Some of our caseloads are very demanding. So it is always nice to be able to look back and remember, when did you last speak to your client and what did you speak to them about? We're lucky here at Maryland Volunteer Lawyers that we have an internal system that allows for us to make notes in our cases, and we can go back to those notes. I hope that a lot of you all have similar technologies at your firms or at your organizations. If not, there are classic ways to keep track of people's information. If you're somebody who still likes to keep a file and have like a note sheet on the front that says the date and making a quick note, that could also work. But any way that you can be able to go back and refer to something when your client says, you told me that you were going to call me next week, you can look back and say, oh yes, I did make a note that I would call you next week. Or that note could also say, I said we're going to meet in 2 weeks. So let's make sure that we're following, the case plan, and we're meeting in 2 weeks and we're not speaking too frequently. The biggest thing is being clear about when the case is over. And when there's an incoming, I personally always like to let my clients know, it's like, well, this is the last hearing. We're almost at the end of our relationship. And I also like to document that via email, so that whenever you do close out the case and you send them a letter that officially closes the case, they're not surprised, that they know, oh yeah, this is coming. We already discussed it. And most likely you would already mention that in person or over the phone, that, it was nice working with you. And the case closing letter is more of a formality. Communication, really, really important. Again, like I said, it's something that I improved on over the years, and now, but any negative issues I've ever had with a client has been over a communication issue, and it hasn't been over anything else. So this is an area that a lot of us can learn from, and I'm happy to. If anyone wants to send me a message about some of my tips and tricks, I'm happy to share those with you all.
Thanks. I just will add one more thing on this slide because it just reminds me a bit of a conversation that I had with one volunteer who's having some communication issues with a client, which is mode of communication. So you might be, and Philip touched on this a bit, but you might be very comfortable with like email or Zoom calls or something like that as a person who uses a computer all day. But your clients might not even have an email, but if they do, they might not check it all the time. They might not ever use Zoom, so they might be very uncomfortable with it. One communication issue that I helped an attorney work through at one point was the attorney was someone who just communicated a lot by text message with their client. And I think it ended up with their clients in general, but I think it ended up being the case that this particular client really just never used text messaging and wasn't very comfortable with it. And so it was kind of like, this client is never getting back to me, and why. And the client felt like, I think the attorney felt like they were communicating very clearly through those written messages, but the client felt like a meeting where they were speaking, whether it be face to face or on the phone, was what they needed to kind of understand what was going on with the case. And so that was kind of just like a classic example of like wires getting crossed. Like both sides were trying to communicate, but neither side was really getting what they wanted from the communication. So one of the things that you might talk to your client about is mode of communication, how they typically communicate, and that's something to think about as well. All right, so moving on to the next slide, working with clients with limited capacity. So with really all of your clients, but particularly with MVLS clients, you may have clients that do have limited mental capacity. Some of our clients may have developmental disabilities. Some of them may be older adults who are have dementia, and so it can. It's definitely something, as the attorney, you have to think about and you have to navigate. I would encourage you. I think sometimes it can be easiest to just kind of take the case with the client that seems like they would be easiest to work with, and I'd certainly get that. But there's a great need for representation sometimes for some of our clients that do have capacity issues, and so I would encourage you both to reach out to MVLS if you find out any of these issues are coming up, so we can try to help troubleshoot, but also not to necessarily shy away just because the client is someone who does have some capacity issues, because they're likely also someone who's very much in need of your representation. So there is a rule, which I've cited at the bottom of this slide, about working with clients with limited capacity. So I would certainly encourage everyone to check that out. But basically what I think it boils down to is that the client should be as involved in the case and in the decision-making as their capacity permits. So for instance, if you have someone who, from the get-go that they do have limited capacity, and they often come in with a sister or brother or, someone who's kind of assisting them, making sure you're not always talking to that other family member when you're talking about the case, and that you're talking directly to the client to the extent of their ability to understand and be involved. There are a lot of people who, maybe they can't make, they're not able to make decisions about very complicated financial issues, but they might be able to make decisions about more simpler issues, like who do you want to live with, like what family member do you want to live with. That might be something that's within their capacity to understand. So just letting the client be involved to the extent that they can be involved in the case is really important. One of the things to keep in mind is that capacity is something that can come and go at different times of the day or from day to day. So particularly, again, that's been an experience with clients who do have dementia, that sometimes you can ask and find out that that person is often most lucid in the morning, and that's a good time to call them and talk to them, and that as the day goes on, their capacity gets less. So I think that's something that's important to delve into if you are having a challenge with working with a client with limited capacity and trying to work through that. Ask the client if there are things that would aid them during the case. Maybe it would help them to have what you're telling them in the format of a checklist that they can check off, so that when you say, I need X, Y, and Z items from you, and their memory is a challenge for them, having that on a piece of paper that they can bring home with them to jog their memory could be what they need to get you the items that you need for the case. So I would definitely, put it out to the client. They may have different strategies that they've used in other settings that have been helpful for them that can also be helpful to you in the case. Just a few tidbits about working with clients with limited capacity. And again, like I think my overarching theme here is to reach out to MVLS, to your intake paralegal who placed the case with you, to myself, to Sarah, to any of the staff attorneys here. If you are having a challenge with a case, we can potentially help work through that, whether that be giving strategies or even reaching out to the clients ourselves and saying like, look, your attorney's having trouble getting in touch with you, or whatever the case may be. When to consider ending the relationship. Sometimes it is the case that you do need to terminate a client relationship. So what I would say about this is, we prefer that the first thing you do is reach out to MVLS, and I kind of just talked about this, but if there's something going wrong, there might be something that we can do to intervene. For instance, a communication issue, we might be able to get the client involved again and, say to them, look, like your attorney really needs to speak to you every week, or you really need to get X, Y, and Z, the documents in, or this case is not going to go forward. And we might be able to help get that jump started again. Are there any other ways to proceed with the case? So okay, so what I meant by this slide when I put it up there really was, we sometimes have situations where an attorney has given a client advice and told them what the likely outcomes of their case are. And, oh, are you intentionally raising your hand? No. Okay, so the client doesn't want to do what the attorney's advised. The client just has their own ideas of the way the case should go, and they are doing something that the attorney does not think is advisable. We sometimes have attorneys reach out to us in those situations and say, I want to end the representation here because my client, I've told the client that I advise X, Y, and Z, and they're just not willing to do that, and that's not what they're doing. So, one of the strategies that you can use in that situation, short of actually ending the relationship, is to send the client a letter documenting, this is what I advised you to do. And you have told me that you're not going to proceed with that plan. In that way, you can kind of cover yourself in that you're documenting that you gave the client good legal advice about what they should do, and the client chose not to follow that advice, and that happens sometimes. I guess what I'm saying is I would encourage you to think about that not in every case like that you need to end the relationship. It might just be a matter of making sure that you've well documented what you've advised the client to do, and they've decided to do something different.
Right. Can I add something?
Yep.
I would also go back to that agreement, the representation agreement, really helpful, where you can say, hey, this is outside of what we discussed in that agreement. I said that I needed our communication to be like this, and that you would follow my advice. And right now, you're not adhering to the agreement. I think that's really helpful as well.
Yeah, and frequently, if I have an attorney reach out to me with any kind of issue, like one of my first questions is, what was in your representation agreement? Like, what did it actually say? Because oftentimes, like you said, that is the solution to what's going on. The other thing is, be aware if you've entered your appearance in the case and there's an ongoing litigation, you do need to seek permission from the court and notify the client that you're terminating your relationship if that is the way that things that things proceed. So sometimes the court will let you out of the case and sometimes they won't. That is, something that's up to the judge in that situation. And so it's not certainly not up to MVLS, and may not necessarily be within your control whether you can get out of that case or not. And we've also cited a rule about terminating your client relationship. But if you do get to a point where you need to get out of a case, step one would be contacting us to let us know. Step two would be seeking permission from the court and notifying the client, and then closing the case with MVLS is also very helpful to us, because we do need to know that that case is no longer actively being represented by one of our volunteers. So that is terminating the relationship, and potentially finding ways to work around issues rather than terminating the relationship if that's possible. Okay, so really quickly, and I just want to stress, because I don't want this slide to scare anyone, by no means do many of our volunteers get involved in disciplinary action. So don't think that that's something that's likely to happen to you as an MVLS volunteer. But we did have a presentation where we asked Lydia Lawless, who's bar counsel, to come about 2 years ago and do a presentation for us on the most common disciplinary actions that they see. And you can watch her presentation on our website if you want to. But she shared that the most common issues that they see are competence, diligence, and communication. So I think that really tracks with a lot of what we've just gone through in the previous slides. And it's good for you to be aware of what things are most likely to get you into hot water with a client, so that you can plan on the front end, and again, make your representation agreement really solid, make your plan for communication really solid. The more you can do those things on the front end, the less likely you are to get into any kind of a situation where you're going to have a complaint on the back end. Philip, I think I'm kicking it back to you for this slide.
Yeah, thanks for not dwelling on that last slide.
It really doesn't happen a lot. I'm not exaggerating there, but it's good to know.
Yeah, no, we've seen a variety of things. I've read some of those disciplinary actions that happen. I'm like, oh gosh, I don't want that to be me. Yeah, so here, let's talk a little bit about dishonesty, or not sharing the full truth. Before I got to MVLS, I was at this place called the District Court Self-Help Center. So we saw a high volume of people that were coming to the district court for various matters. And they would describe the case in the best light that they could. And we sometimes would help them, draft a complaint or whatever we were up there to do. But I would always stress to them, it's like, there is an opposing side, and they're going to have evidence potentially that could make you appear dishonest before the judge. And when I was representing folks, I would always tell them, it's like, you don't want to put me in a situation where it appears that I'm being unethical by withholding important information or withholding something that is obvious and that's on its face the truth, because you weren't being honest with me. And again, the judge doesn't know that I didn't know. So, I'm letting the client know that you put me into a situation where I appear to be unethical. And then also being honest about the material issues in the case are important, and because it helps set expectations. And I think a lot of us have been in a situation where someone, gave us a story that was not completely true, that was, again, in the most favorable light that they could see. But they say, oh, I forgot that I didn't make that payment, or, oh, that person did pay me, or I forgot that I, tapped that person's car a little bit harder than I said I did. Because you end up in a situation where you're like, well, I told you that these are the possible outcomes, and now these aren't the possible outcomes. So again, the communication at the beginning is super helpful. And then if these things pop up, you can say, hey, remember, like I needed you to be honest about this. And now our case is different. And we may need to change our strategy. And this may not be at all what I promised at the beginning, or I said as possible outcome. But then you have to always ask yourself, like, why is your client potentially being dishonest or maybe not telling the full truth about something? It could be a lack of sort of education around an issue. It could be that they truly forgot and that they missed something in their retelling. And so it is important to sort of try to gauge those things and maybe not attack your client when you find out that something isn't true. So I always avoid being too accusatory. I was like, did you know about this? Did you recall seeing this receipt? Really important strategies because again, the relationship you want to preserve. And then you want to explain to your client the importance of, honest testimony and how it will help their case. We can go to the next slide. One of the things that I found in working with a lot of folks is that oftentimes they get into situations with an opposing party, and the problem maybe isn't always money. It's that they're upset about something, that they feel like they were deeply wronged by the opposing party. I've seen people who've been in relationships where they're asking for things and they're overvaluing the items, and of course it comes out in court that the value of the item isn't what they initially said. But when that came out, I said, well, why did you tell me this thing was worth $2,000 and it was only worth 200? And they eventually are like, I was just upset. This person should have to pay for my feelings. Or they, I was like, well, that's a different argument. That's a different type of case. And that's not what we presented to the court. But so recognize that happens in the landlord-tenant situation, and that happens in some of these contract situations where someone's like, I just don't feel like this person or this organization or this group should get this amount of money or should get this thing. So understand that frustration can come from the dishonesty can come from other things. And they were again hoping that their attorney could help them clear up this feeling that they have versus what can actually be done within the bounds of the law. The other thing that we have here is talking about offering empathy. I have a great depth for empathy and being able to show that with people, but I recognize a lot of folks don't. And there are some ways to sort of practice empathy, and there are ways to sometimes just reflect what your client is saying back to them. There are whole trainings on things like this, but it's always good to sometimes just repeat what your client has said. It's like, are you saying that you're upset because of this? It's really helpful because it gives you an opportunity to hear what they're saying, and then it gives them an opportunity to also say, yes, that is what I'm feeling, and feeling like they're actually being heard. And even though sometimes we can't solve that feeling, them being heard and them being at a place where they feel like you get where they're coming from allows for you then to move on with the case. Because you can then say, we may not be able to solve that feeling in this case because of the X, Y, and Z reasons, but I do hear you. I do understand why you feel that way. But let's focus on the things that we can solve. Oftentimes that clears up a lot of the communication issues. We talked about here about trying to de-escalate the situation, trying to speak calmly and slowly in an even tone. I've been told my tone comes off maybe a little too pleasant. So I try to bring it down.
I want an angrier attorney. I don't know.
Down, right? But yeah, because oftentimes when someone's retelling a story, they're getting upset while they're retelling the story. A landlord-tenant case, I can remember someone described their child being injured because of a condition in the property. And I could tell they were agitated just by going over this thing that happened 6, 8 months ago. But remember that, yeah, your goal is to get the facts and not to feed into that agitation. Um, and so that goes back to my point about not being very accusatory when there's something that isn't true. Um, or if you have a feeling that something isn't true, just keep asking the questions until you get to something, until you get to the answer that you think is the most honest answer out there. And then also, this goes back to when our sort of bat signal goes off and maybe we're wrong. If we're wrong, because we're not always right, it's so important to let the client know and say, you know what, I'm so sorry. I think my sort of line of questioning led you to believe that you didn't make that payment. And thank you so much for sending me that receipt that shows that you did make the payment. I want to let you know that, I was wrong for if you felt at all upset by my tone or by my posture in questioning. Again, that changes everything. That person then's like, okay, again, it gets you closer to understanding who they are, where they're coming from, and then them feeling like you're on their team. Um, there are definitely times when you need to take a break and you need to say, okay, this conversation isn't productive. Um, and I've had times where the person is upset and they're not necessarily upset with me. They're upset because they've been upset about this issue for a while, and rehashing it has made them even more upset. There are different ways that you can tell them, say, hey, let's take a pause and come back, or let's talk again tomorrow or next week, and maybe have them write down some of their thoughts. Um, just figure out a way that they can get their thoughts out so that it can just be reviewed, and the person maybe be a little less angry. The one thing that, I mean, I've seen it, I'm sure Margaret's seen it. You're an attorney, you're a professional, you're not someone who's here to take abuse. Uh, Definitely don't find, if you find yourself being threatened physically or being threatened or abused verbally, I we know where your limits are, and let the person know that, hey, this language isn't appropriate, or I see this, your posture is threatening. um, and make sure that they're aware of it, and definitely don't take abuse. I will say the one thing, I have interacted with clients, and this helps when you've seen so many clients who are loud and sort of have a sort of aggressive sounding posture to them. Some That is sometimes a cultural thing. That is sometimes just, this person is just a very loud talker. Try to get to know your clients too a little bit before making any decisions about whether they're being abusive. But I definitely had one client. I was like, this person, are they yelling at me every time we speak? They feels like they're yelling, and I got to know. I was like, okay, you're just very, very loud. So anyway, all those things, anger, frustration. Margaret, feel free to add
Yeah, no,
if I missed anything.
I totally agree with that. And like, it is helpful to sometimes try to, you know, figure out where the client's coming from. However, like, certainly if the client's being, physically threatening, like, we have, in addition to your representation agreement, we have terms and conditions the clients sign about participating with our program. And that would certainly fall out, outside the bounds of what we allow in our program. So that would definitely be a legitimate reason to terminate your relationship with an MBLS client if anything like that is happening. Okay, so the next thing we're going to talk a bit about is trauma and how that might be affecting your client in their case. So I will say, my background is I'm an attorney. I'm not a social worker or a medical professional who's been trained in trauma, but this information on these slides, much of it is from a presentation that was done by a licensed social worker who was kind enough to share it with us. So I will go through some of it and just, share what I have to share with you, but I would definitely encourage people to delve more into this issue if you're interested. I've also seen some really interesting presentations specifically on trauma, if that's something you're more interested in learning more about. But many of our clients have been through life events that are traumatic, and those can have ongoing responses. It's not, if you were robbed in the middle of the night, it's not like at the end of that it's over and you're done with it. You very often can experience some of these reactions that are listed on this slide, whether that's re-experiencing the trauma, depression, anxiety, anger, avoidance in general. And so that could be avoiding what's going on in your case. That case may have nothing to do with the trauma that you experienced from the attorney's point of view, but that can be a general reaction that someone has to things that are going on in their life because of the trauma they experienced. Just distrust in general in terms of someone's view of the world, paranoia, fear, and feeling on guard. It can manifest in, it can be very difficult for a client to be sitting with their back to the door and have someone come in the door when you're having a client meeting. So there's just things like that that you may not, you're probably not aware that you may not be aware that your client experienced trauma, but many of our clients have. And so there may be certain things that are going on in your relationship with them that are a result of their trauma. And when you understand that is why they're behaving in a certain way, it can potentially help you kind of navigate how to interact with that client. So the client, may not be answering your calls and might be missing appointments. That might be related to the avoidance we talked about. They might have difficulty focusing on tasks. And if that task is, getting something that you need for the case, that can be very frustrating to you. So, some tips for making your client relationship better if some of these things are going on is make sure you are acknowledging how the client is feeling. Make sure, and this is kind of a theme throughout our whole presentation, but setting expectations of what's going to happen at the meeting, what you need them to do in advance of the meeting, what needs to be done for follow-up, circling back with the client to remind them, I needed you to get me X, Y, Z within 2 weeks. It's been a week and a half. This is really important that you get this to me. And so these are some strategies that you can use if your client is having difficulty focusing on some of the tasks that need to be done for the case. The other thing is just being aware that sometimes the client's trauma or your own trauma can impact you in your representation. So your client's experiences that they've experienced may trigger things in you. So just to be aware of your own feelings and your own behaviors and reactions to things that are going on in your cases. Secondary trauma is a very big issue in the legal services world, because we are working with so many clients who are experiencing such just terrible life circumstances in a lot of situations. And so as a volunteer, you also you may find this with your pro bono cases. So it's really important to engage in self-care. It's really important to tap into your own support system and to set boundaries. And that's something we're going to talk about in just a minute, about what you can and can't help with, and how, protect your own well-being as well when you're working on cases with pro bono clients. Just to talk, we talked a bit about structural racism and implicit bias at the beginning of this training. We pulled some data from 2019 in terms of who our clients are. And you can see here that in our consumer client cases, 77% of our clients are Black. That is way off the general population in Maryland, in terms of the percentage of Marylanders who are Black. In our housing cases, 66% are Black. You can see this, the statistics for our expungement and family law cases. So basically, we know that a disproportionate number of people who are experiencing the legal system without an attorney are Black Marylanders. And we know that structural racism has a role in why that is, and is also something that your clients are going to have to contend with in the legal system. So the reason that I bring this up is, when we talk about the challenges your clients face just at the beginning of the training, and also the trauma that we just talked about, that none of this can be seen as a vacuum. It's in a vacuum. It's not like, your client experienced one traumatic event and that's totally disconnected from everything else that's happened to them in their life. So it is really important, and I think we've stressed this throughout the training, to consider what is going on in your client's larger life, how that might be impacting the case or the relationship. Acknowledging your client's lived experience might be different than your own experience. And I think that story that Philip told earlier about the client who overheard a conversation that was happening between the judge and the opposing counsel in a case, and kind of made an assumption that their case was going to go against them, was a good example of this. Like, your experience of going into a courtroom and seeing the opposing counsel having a conversation with a judge is likely very different than that client's experience was. And that doesn't mean that one is more or less true than the other, but it's really important to know that that your client might have a very different experience than you, and that that is, impacting their viewpoint, how they're seeing the case, how they're seeing your relationship. And another thing that I think is really important to this is you're never going to know what your client's lived experience is unless you are being an active listener to what that client is sharing with you. So, people may or may not choose to share their experiences with you, but don't make assumptions about what a client has been through, how they think about things, what their life is like. Listen, really try to actively listen to what they are sharing with you, rather than going into a relationship making assumptions about what that person's life is like. And then recognizing the legal system is not always fair. I think, as lawyers, and just as Americans, I guess, we have this like ethos that the legal system is this, the beacon of justice and fairness, and the outcomes are the same for everyone, no matter who that person is. And in reality, when you, again, look at that last slide of who our clients are, the legal system is not the same regardless of who you are. The outcomes are not the same regardless of who you are. And so recognizing that, and I think this also goes to the point of we can't work a miracle sometimes and get you the outcome you want in your case, because it's like the laws are often stacked against our clients and what their goals are. And so acknowledging that can be helpful to your relationships with your clients. So this is a very large issue. By no means can I claim to say I'm going to tell you in this one slide how to navigate structural racism in the legal system. But just a few notes that we had come up with as we were thinking about our own experiences and preparing for this training. Okay.
Yeah, thank you, Margaret. Yeah, so true. It's all of that, and yeah, at MVLS, it's important for us, and we are an organization that we are an anti-racist organization, and so it's important that we have those slides and that we talk about it in our presentations, and so yeah, hopefully we all can do our part to make things more fair here in the state of Maryland. So one of the things I wanted to discuss here is clients with non-legal issues. This again goes back to setting boundaries, letting folks know, hey, I'm an attorney, this is my area of expertise. As an attorney who feels pretty comfortable with knowing where certain resources are, I find myself, being able to share resources a little bit better, but there are some areas where I have no clue. And it's important to recognize that if you're a volunteer with Maryland Volunteer Lawyers, you have us. You have our organization, you have, we have an extensive list of resources that we're always willing to share, but it is always helpful to reach back out to your intake paralegal. I would say that they are great, and I would say they're experts in knowing where certain social services are and how to provide those referrals. And then if you feel comfortable, you can also share information about contacting DSS or other social services that you know and that you have contacts with to help your clients.
Great. Clients with financial issues, just wanted to touch on these resources really quickly to make sure everybody's aware of them. But we do expect our volunteers to try to request a filing fee waiver if they're filing an MVLS case and it's applicable. So this is something that is available on our website. It's pretty easy to do an MDEC. If you're filing a case in an MDEC county, let us know if you need any assistance with it. But even if the filing fee, seems small, it can make a difference to our clients who have very limited income. So that's something that we would really request and encourage you to do. The Pro Bono Resource Center has something called the Litigation Fund, which we also strongly encourage our volunteers to use. It can cover costs that are not waivable, like filing fees. And so this is something that's available for pro bono attorneys throughout the state. So please utilize those two things. I am going to ask if anyone has any questions, feel free to type them into the chat. Just really quick, this is how you can follow MVLS on social media. We post a lot on social media. We encourage you to check out what we have available. If we have trainings and things coming up, we'll share those events. If you are interested in taking a case, we have our pro bono portal, which you can see featured on this slide, how to get to the pro bono portal. And this is what it looks like. So you can sort your cases by case type and by jurisdiction to see what we have available and look at a little blurb of what the case is about and see what you might be interested in taking. We have recorded trainings on really every single topic, every type of case we do, available on our website and live several times a month like this one. So please check out our list of trainings, and a lot of them are totally free. They're all totally free. Some have a case requirement, but a lot of them are just don't have any requirement, and you can just click on them and view them. And if you're not a volunteer yet, please visit our website and sign up to be a volunteer. All right, so with that, I'm trying to go back to my stop share. I don't think I've seen any questions. I know we're a little over the hour that we were scheduled to go for. If anyone has any last minute questions, feel free to type them into the chat now. But not seeing any. I think I will say again, thank you all for attending. We really appreciate it. And please reach out to us if you have any questions or thoughts to share. Thank you all.
Thank you, everybody.
Bye.